just because you're small and they're big and they're going after you for trademark infringement doesn't mean that they're bullies. It could be that you're an idiot. I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's targeting VI target. I'm sorry, what? Alright, I'm going to start by reading from the article, and you can always find the link in the description below. We're also going to go through the document that Target filed, and that's going to be lots of fun. Alright, so let's do this. Corporate giant sues VI retailer alleging trademark infringement. A dispute over use of a registered trade name has led retail giant Target Corporation to file a civil lawsuit against the Virgin Islands company doing business under a similar name. Attorneys representing the Minnesota-based firm recently filed a 2-count civil complaint in U.S. District Court. According to the complaint filed April 29th, Target says corporate officials contacted executives from VI Target Liquidation Center LLC in October, asking that they cease and desist use of a logo they said was designed to confuse consumers. The civil suit alleges Federal Service trademark infringement and false designation of origin. The account is asked to enjoin and restrain the local merchant from using the logo, pay monetary damages, and attorney's fees. So Target, they say how big they are. VITLC, doing business as VI Target, began doing their business several months ago in a retail space near some regional medical center. Okay. Portion of the complaint describes the alleged So we're going to go through all that. And so I'm going to go walk you through this in the actual document because it's so good. What they say is when corporate representatives wrote to the local retailer outlining their complaint, court documents said the company received a written response rejecting Target's request to cease and desist use of the name VI Target. And the same name and logo appeared in social media ads that were featured as illustrations in the federal complaint. I'm going to show you all that as well. According to the Office of Lieutenant Governor, Division of Corporations and Trademarks, VI Target Liquidation Center registered as a limited liability corporation, but the trademark has to first be filed with the U.S. Patents Office, and that does not appear to have happened. Well, of course it didn't, because if they filed it, it would have been thrown out like this. All right, so now what I'm going to do is I'm actually going to open the lawsuit and quickly walk you through that just to give you some ideas as to what usually goes in documents like this and what you should pay attention to. So here we go. Yep, so this is the opening. So complaints against defendant VI Target. Here are the parties. Here they explain why they would be filing in the District Court of the Virgin Islands Division of St. Thomas and St. John, the jurisdiction and venue. This is just the legal formalities that have to go in a lawsuit. And then they say, well, here are the allegations. They say Target has since 1962 operated a chain of retail stores. Over the years, they became so well known. A lot of people know about them. They own a bunch of trademarks. Among them, these trademarks, those trademarks. That's their logo. They got the name all registered for a bunch of different things. And so they got all those valid trademark registrations. They spend a lot of money. So they say great sums of money and substantial effort have been expended in establishing, promoting, and protecting the Target mark, Bullseye Design Mark, and Target and Bullseye Design Mark, collectively the TBI marks. So the reason they mention the time and effort to protect and promote is to show that it's not just some obscure trademark registration that nobody knows about, and the only way they would know about if they just did a trademark search. They say, yeah, of course it's a registered trademark, but it's also a brand that millions of people all across the US and the world know about. So don't tell us you didn't know. That's what they're trying to say. Don't tell us you didn't know. Don't tell us you didn't think about it. Of course you did. So let's keep going. Yeah, this is exactly what they say. Through long and extensive use and promotion of the TBI marks and through exercise of control over the quality of goods and services offered thereunder. Now, about control of the quality of goods and services, that's a reference to licensing. Because sometimes you don't use your trademark yourself, you license it to others. And the licensing agreement requires, the trademark licensing agreement requires that you exercise control over the quality of the goods and services that are being offered by the licensee under your trademark. Because if you've got products of completely different quality offered by the licensor and licensee, then you have a problem with protecting the consumer. One of the reasons for having trademark laws is to protect the consumer so that the consumer knew that every time they buy a product under a certain brand, it's of a certain quality. And if licensee's quality is totally different from the licensor's quality, then we have a problem. So Target is saying, yep, we are exercising that control. Don't worry about it. We know what we're doing. So they say substantial and valuable goodwill and consumer recognition have been built up in the TBI marks. And retail consumers have come to closely associate the distinctive and valuable TBI marks with Target Corporation and its operations. Of course they do. The TBI marks have, through the substantial efforts of Target Corporation and TBI, come to represent known quality and convey value to retain consumers. Okay. So neither TBI nor Target Corporation has authorized VITLC to use in any fashion whatsoever any of the TBI marks or any mark or designation confusingly similar to the TBI marks. The reason they mentioned that they didn't give them permission is very simple, because one of the defenses against a trademark infringement lawsuit is say, what do you mean we're infringing? You gave us the license, you let us use it, we asked you and you say it's okay. So in order for the defendant to not be able to make that argument, they said, no, we didn't give you any permission. We don't know who you are. You didn't ask us permission. We didn't give you permission. We wouldn't have given you permission. So don't even think about going there. All right, let's keep going. They say, here's their wrongful conduct. So it's not enough just to say, well, we own the trademark and a lot of people know about us and you didn't ask us permission. That by itself does not constitute trademark infringement. What constitutes trademark infringement is actually if you did something with the brand. So let's see what they did. So they say VITLC operates a discount department store in St. Thomas, Virgin Islands under the name VI Target. Its exterior store signage, here it is. It says VI Target with a logo. Alongside, so prominently displays the name Target in red letters. Of course it has to be red, right? Same color as our Target. So, do you think that's a coincidence? No. Okay? Alongside a red and white bullseye design, nearly identical to the bullseye design mark pictured on the right below, on which collectively are substantially similar to the trademark and the bullseye design mark. Okay, so that's a photograph. And then they say, indeed, VITLC even presents the word Target in a font very similar to one often employed in presenting TBI marks. So here's what Target does, here's what these guys do. Fonts are similar, but I mean, it's a generic font. It's not really that well recognized. So let's keep going. In advertising and promoting its VI Target department store, including in print advertisements and on social media, VITLC prominently displays the name Target in red letters under a bullseye design that features the R in a circle symbol, a wrongful and confusing reference to TBI's federal trademark registrations, collectively with the uses described in paragraph 16 above, the infringing designations. So then they have this VI Target, and they show the R in a circle, and this is what they have on their Facebook. And so let's keep going. Through its VI Target store, they provide retail sales services under the infringing designations, which include, among other things, sales of men's, women's, and children's clothing, shoes, and accessories, toys, housewares, and school supplies. Why do they list those? Well, because Target's own trademarks are registered, among other things, for those particular products and services, the apparel, the household stuff, and because trademarks don't give you the absolute monopoly over the brand, they give you the monopoly over the brand in connection with specific products and services. And here what they're saying is they're using brands that are very close to ours for exactly the same stuff that our brands are registered for. So these are bad guys. That's what they're saying. Let's keep going. Upon information and belief, that's a term they love to use in legal documents, which means we think that's the truth, but we are not necessarily able to prove it. And we want them to prove otherwise if we're wrong. They say they commenced its competing use of the infringing designations in 2018. Well, after the first use of the TBI marks, the reason they mention it is if VI Target had been selling products in their liquidation stores centuries before the big Target started, then they would have a perfect defense that we started before you register your trademark, and we can be allowed to continue doing what we have always been doing even before you register your trademark. So Target is saying, it looks like you didn't start your business under this brand before we did. So yeah. And then they say also that that use was with knowledge of the TBI marks and of the retail operations then existing under the TBI marks. So again, they say upon information and belief, because, well, how can they know, how can they prove that VI Target knew about Target? They can't prove that, they just think that way, correct? And so again, if VI Target wants to prove that it had no idea about Target stores, well, good luck trying to prove that. Again, they say upon information and belief, it commenced use of the infringing designations with the intent to trade on the goodwill and consumer recognition that had been built up by the TBI marks. Yep. Their use of the infringing designations likely caused confusion and mistake among consumers as to the source of origin of VI TLC's retail services and the non-existent affiliation between VI TLC's operations under the infringing designations and the operations of under the TBI marks. So they say, well, what you're doing in such a way that a lot of people might be confused into thinking that there's some connection between you and us, and we don't have anything in common with you. We don't want to have anything in common with you. All we want to have in common with you is sue you for trademark infringement. That's what Target says here. Here's where it gets interesting. September 20th and October 12th, TBI sent correspondence to VI TLC regarding its confusing and wrongful use of the infringing designations, requesting that they cease and desist from such use. In that response, so VI TLC actually responded. I'm surprised. So they responded, and in their letter, they said that they will refuse to cease and desist use of the name VI Target, but indicated that VI TLC would immediately cease and desist from using the modified bullseye logo or any variations thereof. So VI TLC has continued the use of the infringing designations, including what VI TLC's counsel referred to as the modified bullseye logo after October 24th. So they said, well, they'll keep the name but change the logo. Apparently they didn't. So their current Facebook advertising still shows the same stuff. And by using the infringing designations in connection with retail services, they're willfully and intentionally trading upon the goodwill. I already said that. And TBI has no control over the quality of the goods. So they say, well, and consumers will suffer as well. right? So it's not just about us who want to protect our asset. It's also about the people. The people, they will suffer because they have no way of knowing that they're not buying from us. They're probably frequenting VI Target's facility in the hope that they will be greeted with the same supreme quality of goods and services that they can expect in the Target stores. And we just can't guarantee that because we don't control VI Target's products that are being offered in their liquidation stores. Okay, so let's keep going. So, and also they're saying that by doing all this, VI TLC thereby has cost and is causing them substantial and irreparable harm and injury. Again, when they say irreparable harm and injury, doesn't mean that Target can't recover from this, right? They don't really notice. But what's happening is that what Target is trying to do is say, we don't just want the money. We also want them to stop doing this because money can't repair the harm that we're suffering because of their actions. So there's two things a trademark owner can get if they win a trademark infringement lawsuit. They can get money and they can force the other side to stop doing what they're doing. And money is easy, right? There's an infringement, pay us the money. But in order for the court to force the other side to do something or stop doing something, what's called a permanent injunction, you actually have to show that if the court doesn't do that, that you continue to suffer harm. That's why they're talking about irreparable harm. Okay, so there's two counts that they're going after. The first one is infringement of federally registered marks. So they say, well, we got all those trademarks, they're not authorized, and their actions constitutes trademark infringement, causes confusion. So basically they're just going through the textbook requirements for what do you need to prove trademark infringement. They say, well, this, okay, here's how we're gonna prove it. They did this, and this. And so the first one is the trademark infringement. The second count is false designation of origin. So that's slightly different. So they say that VAI TLC has used and continues to use the infringing designations in commerce and distributes, advertises, offers for sale, and sells in a manner that is likely to cause confusion. So basically exactly the same thing. And TBI then will be damaged and no adequate remedy exists, and acts of false designation of origin have caused and continue to cause blah, 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 blah. So same idea. It's basically just two different ways to get at the same thing, right? You use different laws for that. You do different statutes. You use common law. You use different cases. The whole idea is pretty much the same, but sometimes you plead it separately. And then they say prayer for relief. That's basically what you're trying to get the court to give you from the other side. They say, well, they want preliminary and permanently enjoin and restrain VI TLC, its officers, agents, servants, blah, 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 and anyone else from participating and using those marks. So preliminary means before the court makes the final judgment, and permanent means what's going to happen after the court reaches the final judgment. Then they want monetary recovery in an amount to be proven at trial. So they're going to show how much the other side has made, or maybe they're going to go for statutory damages. So they're going to be talking about numbers at trial. And then this is going to say they want find that this is an exceptional case within the meaning of 15 USC and award TBI its reasonable attorney fees. So in the US, just because you win a trademark dispute doesn't automatically mean that you get the attorney fees. So here they're saying this is an exceptional case. This is so exceptional. We believe we should not just get them to pay whatever damages, they should also pay us for our attorneys. Our attorneys work so hard to nail those bastards. We would like to get them to pay for our attorneys. That would be only fair. because this is such an exceptional case, right? And then they say they want the court to grant TBI such other and further relief as the court may find to be just and proper. Okay, and then they say they want jury trial, and that's how a lawsuit looks like. So there, I hope you found this thing useful and interesting, and maybe you learned something that you didn't know before. And if that's you, and if you haven't subscribed yet, well, what are you waiting for? Subscribe right now and get notified whenever the next video goes live. And if you got a brand that you want to protect, if you are running a business and you want to make sure that as you grow and you build your business into something that matters, and you build a brand into something that people recognize, you got to protect the brand because it could be your most valuable asset. So if that's you, go to trademarkfactory.com and book a free call with our strategy advisors, and they'll help you get started. And until then, I'll see you in the next video.